Welcome back, everyone, to our Small Fleet and Owner Operator Summit. And in this chat in particular, we are diving into a very interesting and debated issue of broker transparency. Now, everyone, don't freak out, because we, of course, have one of our favorite lawyers here from the industry, Matt Leffler, the Armchair Attorney himself. Matt, please introduce yourself to our audience and those who might not know you yet.
My name is Matthew Leffler. I am the Armchair Attorney. I'm a lawyer who's been practicing in supply chain for the better part of 15 years. I am an adjunct law professor at Michigan State University College of Law. Go Green.
Go
and
white.
I'm excited to be here to talk about supply chain and transparency. I can't get enough of it. I need to see more.
Well, it's a very interesting topic because I think, of course, you got the legal side of it that we'll get into, but then, of course, I think a lot of how do we move past this in terms of building relationships and kind of the core problems that lead to transparency becoming an issue. But let's start at the interesting lawsuit that you, of course, were wonderful enough to write about here for our audience here at FreightWaves that did numbers. And I think it's because, again, in this tight market in particular, carriers are very interested about where, those percentage points are going. So can you give us an overview of the recent lawsuit between Pink Cheetah Express and TQL and how it services this discussion in broker transparency?
Absolutely, Grace. And you hit the nail on the head. This has been an issue we've been talking about, not just recently, but it's been a decade or many decades of conversations. And the real fundamental question is, who gets to know what about a brokered transaction? Do the shippers, what they pay the broker, is that something the motor carriers should know or they must know? And this case with Pink Cheetah really defines this issue so well. The story goes back to a small motor carrier who was hauling loads for TQL. And when they made a move of ice cream, they asked for copies of the records. And TQL cited what they had in their broker carrier agreement that said, hey, you waived that right. You waived the right to transparency. And ultimately, Pink Cheetah went to the FMCSA and said, I would like you to force them to tell me how much they were paid. And when they did finally find out exactly how much TQL made on that load, it was like 40% of the total revenue that was given to the broker. So it was this idea of how much do brokers actually make? And some motor carriers think that brokers make enormous amounts of money. And the reality is it's probably not the case. It's more likely than not they're 12 to 14% of margin. But this one load showed a story for Pink Cheetah that there was more there. And they asked for more records. They had 14 other loads that they had moved, and they didn't get copies of those records. So Pink Cheetah filed a lawsuit in the DC circuit asking to have the records produced to them and to ultimately have TQL not use that waiver any further and to knock it out completely. And that is the central issue of this case.
That's interesting. Where does that broker transparency law originate from? What was the original point of that in particular?
This is one of the most fascinating aspects of this business. So in the old days, it was all, big motor carriers working with shippers, and brokers were kind of little small tourists in the space.
Yeah.
And what they ended up doing was they would work with motor carriers to find backhauls. And so how those relationships would work is the broker would find a new load for that motor carrier, but the shipper would be paying that motor carrier directly. And so the broker was the one saying, hey, I get a portion of that. Can I have a record request and see what it is that you actually were paid? And that has evolved over time. Today, the transaction is not between the shipper and the motor carrier. It is two separate transactions. One transaction between the shipper and the broker, and a separate transaction between the motor carrier and the broker. So the times have changed, and the FMCSA is now, it has this as part of their skill set, but their mandate has never been about transparency. Their mandate has always been about safety of the commercial vehicles and the drivers that occupy them. So this issue is continuing to get traction. Just earlier this last year and then into this year, the FMCSA put out some proposed rules around broker transparency. 5,000 people commented. So there's no doubt this issue is something that really deeply resonates with the transportation community.
And with that proposed ruling, right? What are they, I guess, looking to maybe amend in that, right? Seeing that the changing of times, the changing of business operations, right, and between those two parties, the shipper, broker, and the carrier as well. What is that proposal aiming? At least maybe from the comments you've seen so far, are people suggesting ideas of how to amend this, or just flat out against it in particular?
Yeah, this is a great question. So the FMCSA is a $1 billion a year federal agency. They have about 1,000 employees, and in that job, they are regulating over 500,000 motor carriers, roughly 25,000 brokers, 4,000 interstate bus companies, and millions of drivers. And that is what they're charged with doing. And I'll be honest, they're not doing a great job. 20% of all commercial vehicles, if you went out and inspected them right now, would fail because we do not maintain assets the way we ought to. So what broker transparency looks like today is a motor carrier can request records and the broker makes them available if they haven't already waived those rights. Making them available typically means come to my facility and inspect them during these working hours. What the proposed rules have suggested is not only are these things going to be almost required to be produced, but you're going to have 48 hours to comply and they have to be sent electronically. And the industry is really at odds. Some motor carriers believe this is vitally important to their business. Others say, look, I can use pricing tools like Sonar or DAT or any truck stop. There's other things I can figure out how much things cost. But for a motor carrier, your job is to know your operating costs. Like, you price into what you do, how much it costs to do it. So looking at the broker is really a misfire into how you ultimately are more productive. But we really do not know what the outcome is going to be. The federal government, under the Trump administration, has said no new regulations, or for every new reg, we're going to repeal 10. So this issue of broker transparency, again, resonates with so many people. But is it the core mission of the FMCSA? I don't think so. But the Pink Cheetah lawsuit is circumventing the rulemaking process. They're saying, forget about the rules that we're talking about for the future. Right now, we don't think you have the right to waive our rights to transparency. And we don't know what TQL says about this. They haven't filed a response, but we are just in the beginning phases, Grace, and people want to understand what is at stake and what happens next.
Well, let's talk about that. Do you see this going to higher courts? Do you expect that TQL? I mean, in my head, I would assume that they would probably somehow settle their way out of this, because I would think that getting to a point where waiving that right becomes unattainable would be difficult for them in the long run.
This is the real question that we should think about, which is who gets to tell us what we know? Is it the government's job to jump in between private transactions of sophisticated or just businesses in general? Should the government get bigger and look at every single thing that's happening? Or should we allow private parties to negotiate the terms of their engagement? No one forces a broker to work with a motor carrier, and no motor carrier is forced to work with a broker. They have the ability to choose who they do business with. That has been the goal of deregulation. And this pivot into now we want to force people to disclose everything that they've done within 48 hours is kind of bananas. No one has the wherewithal to do that immediately. It's going to require a lot of cost. But to your question, what happens next? Well, TQL will respond, whether they challenge the standing of Pink Cheetah or they say there's no claim here. But regardless, there's no doubt in my mind that this case will get appealed. And whoever wins doesn't really matter. It'll go to the D.C. Circuit. And when that happens, there'll be a ruling, at least on that issue, presumably. But the other circuits are free to interpret this stuff differently. Just like we've talked about with broker liability, where sometimes a broker may be found responsible for the negligence or an accident of a motor carrier, the circuits differ in that interpretation. And we have that same potential issue here with broker transparency. The thing that I'm waiting for and I'm watching for is what the interest groups and the lobbying organizations do. The U.S. Chamber of Commerce, the ATA, the TIA, because after the Chevron decision was overruled and Loper Bright, and I love talking about Chevron.
Yes.
Once it was
we
knocked
love
out,
Chevron here. Yeah.
we love Loper Bright. Chevron, we were very skeptical of. But what is so fascinating is now the question becomes, what did Congress give you the authority to do? Specifically, not what you think you get to do. What does the law say? And there's a real challenge, I think, whether the underlying mandate the FMCSA has enables them to look at transparency as an issue. So this case is more than just Pink Cheetah wanting access to records. There is a fundamental question within our transportation industry of, does the FMCSA have the authority to do this? And if they do, should they be doing this? Are there other things they should focus on? And for motor carriers, it is about running your business, running your own race, making sure that you can profitably stay in business while you safely deliver freight on time and undamaged. But we are just getting started. It is going to be fascinating over the next few weeks and months.
Yeah, I mean, it does seem like it would set such an interesting business precedent, right? To say that, I mean, at what point does a ruling like that start to be brought up in industries, I mean, outside
The
of,
bigger, yeah, the really big issue, if I were to like read through the tea leaves, is you might have hundreds of thousands, if not millions, of motor carriers who have signed these waivers,
yeah,
not having access to those records. Will they be able to go after the brokers they've worked with? Is there potential for class action litigation, which could be
right.
millions of people suing brokers? And as an industry, we really have to understand, if Pink Cheetah's right, the broker carrier agreement that contains the waiver of your rights to transparency are invalid. And if that's invalid, that means that every broker will have to produce records, every single one of them.
Yeah.
So the impact is very, very hard to overstate. It will be substantial for everybody in the business.
Hey, AI is just changing the jobs of brokerage, right? This will allow some person to now be the person who has to make sure these records get sent.
I mean,
I'm
this is that's a real question. Like,
Yeah.
how many technology companies exist today that can go into a TMS, pull out the data, safely and confidentially share that with someone? And what do the shippers think? I mean, why I'm so concerned about
Man.
shippers specifically is they have not made any movement or spoken publicly about whether they have an issue with their records, their confidentiality documents that would be given to a broker and then given to any motor carrier who works with that broker. There's a lot of other uncertainty here, but I think we're so new in this argument, in this stage, that most people don't realize yet what the impacts are going to be.
Yeah, it's very interesting, and the best part about, I think talking with people like yourself is that it puts you in this like state of like kind of confusion for the now, right? But hey, there's freight transactions happening. mm, I'm sure hundreds of them this very second that
Mhm.
you and I are talking. So, what advice would you give carriers who are navigating broker contracts right now and are concerned about these transparency issues, or even if it's not even contracts, just their relationships with brokers? What advice would you give seeing this down the line?
Yeah, first and foremost, let me be very clear. Nothing that I say is intended to
Yes.
be legal advice. This is not an attorney-client relationship. If you think you need a lawyer, you probably do, and it most certainly is not me. That being said, if you're a motor carrier and you're watching this stuff right now, the status quo is those waivers are accurate and enforceable. So there have been many brokers I've spoken to over the last couple of months that say if a motor carrier requests records, we will blacklist them. We are never going to work with them again. So what you should be thinking about as a motor carrier, don't let all the noise of law and enforcement and regulations, that is not something that's going to affect your business today. And it may not affect your business tomorrow. What you have to focus on, like a laser, is making sure you know how to profitably run your company. That is, understand how you manage fuel and maintenance and the assets and the insurance and all the other pieces that affect you every single day. You cannot rely on the government to bail out your company or force your other, partners to work together and force them to give you data. If this is a true partnership, and the goal really has to be you think about partnership in that context, find ways to get direct business with shippers, work with brokers that you can, find them that are easy to work with and considerate of your time, but manage your own business, run your own race. No one is going to come and save you. It is up to you to understand what your operating costs are and why it is that why you're in the business at all, because you like to serve people and you like to safely deliver freight on time and undamaged. That would be my general advice for all motor carriers. And a little bit of helpful news. It does appear that the speed limiter the FMCSA had initially proposed will not be made into an actual federal reg. It seems that they are kind of walking away from that. So a lot of the regulations we've been very concerned with are likely not going to happen. So broker transparency remains an interesting issue. It is still very new in this fight. At this time, I'd say keep running your race and safely deliver freight on time and undamaged.
Matt, again, you are just a wonderful educator in this space. And I want to thank you so much for joining us and our audience today to give some clarity on this issue and some idea of how to, navigate that transparency concept in the transactions that you're doing today, right? So, of course, if people want to learn more about the work that you're doing, where should they go to reach out to you?
You can find me all over the interwebs. Armchair Attorney is my moniker in most places that I go, but LinkedIn and X and Reddit, I'm all around those places. My goal is to help people understand and demystify the law, because ultimately, everyone that I've ever met in my entire career has the capacity and the aptitude to understand what's happening. So my job, as best I can, is to demystify it, make it accessible so that you can make good decisions for your business and for your family.
I love it. Well, this will be airing right near the end of March as well. So hopefully it's a good March for Izzo. It's a good March for you and I. And we'll sign this off with a nice go green.